Good evening, everyone. I am Lian Bon, Rappler's Justice Reporter. And if you're tuning into this recap and is expecting that I have the decision for you, I am sorry, very, very sorry to disappoint you that I don't have that information to you for you yet. What I do know is that the Supreme Court has voted today during its en-banc session, which lasted longer than their usual en-banc sessions. Nakaboto na ang 15 magistrates on what their decision would be on the anti-terror law. That was confirmed to us by three of our sources, and on Twitter, let me just read it. Kinonfirm din siya ni Associate Justice Marvic Leonen. Justice Leonen tweeted, "Votes have been tallied already during deliberations. Please wait for official announcement." And that's an on-the-record confirmation from one of the senior justices. And we were told that an official advisory or announcement will be released today because we were told hindi siya ganun kasimple. It's not as simple as deny the petitions or grant the petitions. There were various sets of voting, and there were voting for each issue or for each section that were raised in the 37 petitions. So we waited until mga 6 p.m. Hanggang ngayon, naghihintay pa kami actually. But I was told that there would be no official announcement today because they are still reviewing their votes. And there are a lot of questions to be asked. What is there to review if botohan na? And that's something that we've been asking the Supreme Court Public Information Office. And I will tweet that as I get the information. But while we are all on standby, holding our breath for what could be the most important decision in our generation, actually, it's a case that would arguably carve the Supreme Court's place in history. Paano ba sila maaalala ng mga tao? What would be the legacy they will leave? Even just it's a legacy, whether it's a legacy of their entire career or a legacy of how they voted in the Duterte presidency. There are a lot at stake. So let's review kung ano ba yung at stake dito sa anti-terror law. Petitioners have called it a very authoritarian law, it's a draconian law, and they fear that if the anti-terror law is upheld, then the civil liberties as we know it today will collapse. You might think that that's OA or that's exaggerated, but let's go through some of the major points that they raised in the petitions and in the 9 hearings of oral arguments noong way back in January, December na tayo ngayon. Number 1 is Section 4. And just a segue, there was a tweet earlier from a radio reporter who said that everything has been upheld as constitutional except Section 4, which is the definition. And Justice Leonen had to tweet that, and I quote him, "Mali po ito, misleading and false information." So we don't have any information what section was ruled upon. So one of the major contention was Section 4 because for the petitioners, the definition is really, really very vague kasi hindi mo alam kung what constitutes terror. And if the definitions are vague for the petitioners, then the law must be struck down in its entirety. And one of the important proviso of Section 4 is yung 4E nasa baba. Terrorism shall not include advocacy, protest, dissent, stoppage of work, industrial or mass action, and other similar exercises of civil and political rights, which are not intended to cause death or serious physical harm to a person. So that was one of the major contention kasi that is very subjective for a law enforcement to define. Ano ba yung magkakos ng death or serious physical harm? Because a law enforcement agent might say what you're doing might cause or will cause or has an intent to cause physical harm. And one of the most memorable, I think, oral arguments for me made in January was from flag chairperson Attorney Chel Jokno, who said that this law punishes our state of mind because it seeks to punish our intent. Sino ba namang may alam kung ano yung intention natin bilang mga tao, di ba? We should be free, we should have the autonomy to think what we want to think, and our thoughts should not be punished. That's basically the overarching or umbrella idea of the contentions to the anti-terror law. Another contention would be Section 9, or inciting to terrorism. Under this, even though the person or the group has no direct involvement in the terrorism or the terroristic act, if this person was found to have incited, whether by written speech or by spoken word or by any material, then he or she would be punished under Section 9, which is an imprisonment of up to 12 years. So under this, activists and journalists have raised fears that baka sila yung target because anything that they can say which may be viewed as radical or which may be viewed as too progressive, or in the NTF-LCAC's view, which may be viewed as very communist, then they could be punished under inciting to terrorism. So again, that's one of the most contentious issues. Another contentious issue is Section 25, which is designation. Before, under the previous law, yung nire-repeal ng anti-terror law, you could be declared as a terrorist group only by prescription, or if you committed a terror act. Pero kung idedeklara ka as a terrorist or a terrorist group, one has to go to court and file a prescription case, which the DOJ under Vitoriano Aguirre tried to do with 600 people, including Joma Sison and others. But that petition failed because nga, the court found that there were not any evidence that these people were related to CPP and PA. So a prescription before meant you had to go to court and go through trial and submit evidence. Under the anti-terror law, sa Section 25, the Anti-Terror Council, made up of cabinet members, can designate you as a terrorist or a terror group based only on their own determination. The hearings are secret. Hindi ka masasabihan, hindi ka bibigyan ng pagkakataong magpasa ng ebidensya na hindi ka terorista, and they'll just issue a resolution. And that, for many petitioners, is the mother of all red tagging, yung pinangalanan ka. And so far, the Anti-Terror Council has designated as terrorists the CPP, NPA, and the National Democratic Front. The NDF is a more parang disputed, it's a very disputed designation kasi maraming activists, prominent activists that we know of, are associated with NDF because they were consultants of the peace talks. So when the ATC designated NDF as a terror group, tumaas, nag-heighten yung fears na ang susunod na talagang target is yung mga political dissenters or yung mga aktivista na kilala natin. So that's Section 25. And during oral arguments, petitioners said that the Supreme Court should strike this section down because it usurps judicial function. So medyo may appeal sila sa korte na kailangan nyong i-declare to as unconstitutional kasi inaagawan kayo ng kapangyarihan. So that is one, Section 25. And another point made during oral arguments is how dangerous designation could be. Kasi merong situation, may scenario dati si Justice, Senior Associate Justice Estela Perlas Bernabe. Sabi niya, what if person A has been designated as a terrorist and he is with person B who's been caught with illegally possessed firearms? What law would apply person B? And the government and the lawyers from the Office of the Solicitor General said, si person B, kahit illegal possession of firearms lang ang dapat kaso sa kanya, meron pa rin daw authority ang Anti-Terror Council kay person B at pwede pa rin siyang ipakulong under the Anti-Terror Act just because he or she was caught with a person who has been designated as a terrorist. And to quote Justice Bernabe, that is dangerous. And now we go to Section 29. This provision authorizes the Anti-Terror Council to order or authorize the detention of a suspect to as long as 24 days. And that is also very disputed because even though meron tayong warrantless arrest, pwede naman talagang mag-aresto ang law enforcement without a warrant, provided that they meet the conditions such as caught in the act, probable cause that a crime has been committed and this person committed it, and if it's a fugitive running from the law or who has escaped from prison. The thing is, under the revised penal code, if you arrest someone without a warrant, you can only detain them for as long as 36 hours. Kasi kung wala kang charge in 36 hours, you have to release that person. And under the Constitution, if we are in a state of martial law and the privilege of the writ of habeas corpus is suspended, you can detain a person for as long as 3 days. So the petitioners are saying, bakit parang humaba? Bakit hanggang 24 days? it is so against the Constitution kahit na nasa state of martial law tayo 3 days lang. So again, that's another the argument, the main argument of Solicitor General Jose Calida is saying that you should deny all these petitions because uh, this is a political question and the Supreme Court has no power of judicial review. And one of the counter argument to that by the petitioner is hindi pumapasok ang political question if you have a clear standard, if you have a clear legal standard by which to decide this case with. And they are saying your clear legal standard is the Bill of Rights. And out of the 20 or more items in the Bill of Rights, the petitioners are saying 15 have been violated by the anti-terror law. So that's where we stand. We know that the Supreme Court has already voted. We just don't know what the votes are. We don't know what the decision is. And so we are on standby. And we've been told that baka wala tonight. And so we will be on standby for tomorrow until, I guess, forever kung kailan nila ma-decide na ilabas sa atin yun. And we're hoping that it could be via press conference where we could ask what caused the delay of the announcement. Again, thank you for staying with me throughout this 12-minute recap. I know that was long, bear with me, but thank you so much, and just tune in to our Twitter on Rappler.com, and we shall give you the freshest information as we get them. Again, I'm Lian, one Rappler's Justice Reporter. Thank you for watching Rappler Recap.